Welcome everyone again to the University of New Mexico Law and Mental Health series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For today's talk, if you have any questions for our presenter, you can enter those in the Q&A box. You can enter those anytime that you feel comfortable, but do know that we hold questions until the end, and sometimes it's not possible for us to get through all of them. If you are pursuing continuing medical education credits, there will be a sign-in sheet, or in fact, there is a sign-in sheet posted in the chat box now. If you are pursuing APA continuing education credits, there will be a link for a survey that you'll complete that will also be in the chat box, but that link will be posted near the top of the hour, near the end of the presentation. So you're going to want to keep your eye on that chat box near the end of the presentation. Make sure you open, bookmark, save something for that link so that you have access to it before the webinar closes. And then make sure that after you complete the survey, you save a PDF version of the certificate afterwards. We don't have PDF versions of those certificates after the fact ourselves. The recording for this week's talk should be available on our YouTube channel sometime later this week. And as a heads up, for next week's talk in the series, we have Dr. Evan August and Dr. Mark Bolden, who'll be discussing historical and ethical views of forensic psychology through the lens of Black psychology. But circling back to this week, I'm excited to introduce you to today's speaker, who'll be discussing wrongful convictions of racial justice advocates that have been facilitated by the FBI. This is Dr. Matthew Barry Johnson. Dr. Matthew Barry Johnson is a professor of psychology at John Jay College of Criminal Justice, the City University of New York. He's the author of Wrongful Conviction and Sexual Assault, Stranger Rape, Acquaintance Rape, and Intra-Familial Child Sexual Assaults that was published by the Oxford University Press in 2021. Dr. Johnson's area of interests are interrogation, confession, wrongful conviction, and racial bias. He currently serves on the editorial board of the Wrongful Conviction Law Review and the Journal of Ethnicity and Criminal Justice. So Dr. Johnson, on behalf of the University of New Mexico, thank you so much for joining our series, and we are excited for you to share your expertise with us today. I'll go ahead and toss it over to you.
All right. Well, thank you, Dr. Perillo. I'm happy and pleased to be a part of this series. I was just learned about this Law and Mental Health series from the University of New Mexico, and it sounds exciting, and I'm happy to be here today. And I have some information to share that I hope will be useful, valuable, and probably thought-provoking for our attendees. And I guess I can get started. You introduced me adequately, and thank you for the introduction. Let me see here. This is the information you already went over with them. I think I need to make an explicit statement about, as far as disclosure, I have no financial arrangement or benefit related to the content of the material that I'm presenting this afternoon. Secondly, disclaimer that the material, the content that I'm presenting are my own content from research I've done and also reflects my views on a number of issues. And these views are not necessarily the views of the University of New Mexico. So let me get into the main part of my presentation. And I want to read a brief statement just to orientate everyone and to keep myself orientated because this helps me as well. But I want to refer to something that's not widely known, that's directly relevant to my talk today on wrongful conviction, the role of the government surveillance, and particularly the FBI. In 1952, W.E.B. Du Bois, who was a noted African-American scholar and historian, he was indicted by the U.S. government. And he was charged with acting as an unregistered agent for a foreign government. And he was indicted and he proceeded to trial. Du Bois was 83 years old when he was indicted. And as you can imagine, this was a major adverse circumstance for him to have to raise monies to defend himself for his activities. Gratefully, he proceeded to court, and he was acquitted. And so he faced no additional penalty. But he lamented after the trial, and he made this statement, which I think is important and relevant. He said that there were thousands of innocent victims in jail today in the United States because they neither had the money, the experience, or the support that I had that led to my acquittal. And that's important, I believe, because this statement was made by him. This is 40, 50 years before DNA began to be applied to criminal investigation. And as a result of DNA, we all had to face up to the fact that wrongful conviction was widespread in the US criminal justice system. So that's sort of my orientating comment. In terms of my objectives for people who are attending, I want them to learn some of the methods the FBI has used to undermine racial justice advocates. I want them to be able to identify racial justice advocates whose convictions, that is wrongful convictions, were facilitated by the FBI. And in my talk, I'm going to zero in on a particular type of criminal evidence, that is multiple eyewitness misidentification. I'll talk about it some more in a few moments. But one of my additional goals is for the attendees to learn and become acquainted with strategies that can be used to evaluate or challenge multiple eyewitness concurrence when it's presented as part of the state's case against a defendant. And that will be drawn from, some of the research on wrongful conviction. So I want to give you a little overview of these issues and a bit of a definition. The U.S. government has been involved in surveillance and disruption of racial justice activism and activists throughout the 20th century, and it continues until today. And what I think I need to do at this point before I go on is to define what I mean by racial justice advocates. So racial justice advocates, in terms of how I'm using the term, it describes individuals and organizations who are involved in lobbying, agitating, and campaigning to secure rights for African-American citizens that are enjoyed by white citizens. So this has included, historically and until today, the right to vote, the right to serve on juries, equal protection of law, equal access to accommodations, education, health services, protection from police and mob violence, and things of this sort. So with that sort of broad focus, there are many, many different racial justice advocate organizations that have been active. And these organizations have different approaches, different philosophies, different strategies that they're engaged in to advance racial justice. And one of the things that I seek to elaborate today is how, regardless of the strategies, rhetoric, advocacy approaches used by racial justice advocate organizations, that they have, as a group, been subject to surveillance, disruption, and so forth. Now, for example, if we look at the period, the post-World War II period, which was a heightened period of racial justice advocacy and controversy. So the period from 1950s to the 1970s. During that period, the prominent racial justice advocate groups were the NAACP, the Southern Christian Leadership Conference, which was Martin Luther King's group, the Student Nonviolent Coordinating Committee, popularly known as the SNCC, the Black Panther Party, which everybody is familiar with to a certain degree, the Nation of Islam, which many people are familiar with as well, CORE, or the Congress of Racial Equality. These were the leading racial justice organizations at that time, and many of them still exist today. Some of these organizations were explicitly nonviolent in terms of their practice and in terms of their philosophy, while other racial justice advocates um, um, supported armed self-defense for African Americans. Some of these organizations sought racial integration, others favored or championed racial separatism. Some focused on electoral politics, while others focused more on self-reliance and economic development. Some emphasized American identity. Other groups rejected American identity. Some of these groups were explicitly Christian in orientation, and others rejected Christianity. But despite these substantial differences, all of these organizations that I mentioned were subject to surveillance and disruption by the Federal Bureau of Investigation in the United States. So let me advance this a bit more in this, making reference to my slide here. So many people today are aware of the surveillance and disruption of racial justice advocates throughout the 20th century and into the 21st century. But by and large, this has been attributed to the former director of the FBI, J. Edgar Hoover. Hoover had Hoover had a very clear hostility toward racial justice advocacy, which is well documented in scholarship. So I'm not going to elaborate on that. But I want to provide two illustrations. Hoover directed the surveillance and aggressive assault on Marcus Garvey in the 1920s, which ultimately led to Garvey being convicted of a federal offense and subsequently deported. And at the time, he had the largest mass organization of racial justice advocates. And then in the 1960s, and I'm mentioning Garvey and King because they're so well known, but there are many others who weren't as well known, who were also subject to this. But in the 1960s, Martin Luther King was the subject of surveillance and disruption by J. Edgar Hoover's, at J. Edgar Hoover's direction, I should say. And an illustration of actually, I'm gonna give an illustration of the attacks against Garvey and King in a few minutes. But before I go to that, I want to advance this other important point, that the hostility toward racial justice advocacy by these forces in the federal government was not something that can be attributed solely to Hoover. And to illustrate that, I want to point out how this occurred prior to Hoover being in the position that he assumed with the directorship of the FBI, which was in 1935. Prior to 1935, Hoover was actually in the Bureau of Investigation within the Justice Department. And that's actually where he was when he directed his campaign against Garvey. But even earlier than that, before Hoover was a key figure, if you go back to 1917, the U.S. had a department called the War Department. Some of you know that the Trump administration has recently decided to readopt that name, the War Department, rather than the Defense Department. But the U.S. had a War Department, and within the War Department, there was a section called the Military Intelligence Division. And they were surveilling and collecting information on people that they considered to be dissidents. And many of them were racial justice advocates. There was a minister in Georgia by the name of A.D. Williams. And he was rather prominent in Georgia. And the Military Intelligence Division opened a file on him, and he was classified as a radical Negro agitator. And within the file, they detailed what was the basis of these categorizations. And one of the things that they pointed to indicate Reverend Williams' radical nature and the radical nature of his demands was that he was demanding that Atlanta have a high school for Black students. Because at that time, the uh, city of Atlanta did not have high school education, public high school education for Black students, only for white students. So he had been relentless in that campaign. And for that, he was um, included in this registry of dissidents as a radical Negro agitator. So that just illustrates that this is not something that is solely the result of Hoover and Hoover's vagaries. And there are other instances from that area, that period. I'm not going to go into them now for the sake of time. Cornweeble, who did a lot of early research on so-called intelligence organizations in the U.S. government, said that by 1919, the United States had a modern political intelligence system in place. Garvey's, no, excuse me, Garvey's targeting by Hoover, that proceeded in the early 1920s, and actually the prosecution of Garvey became a key accomplishment for Hoover and advanced his career in law enforcement. German is an author who has addressed these issues in the going into the 21st century, and also me, and has a very valuable law review article that shows that these things have continued even in the aftermath of Hoover's position as director of the FBI. I'm not going to talk about their work right now, or actually today, because I have other things I want to cover, but I just want to point out that this remains an issue. So what are the government methods of surveillance and disruption? There are a variety of methods that are used. Today, we're going to focus on the final one I have here, criminal prosecution. I seek to demonstrate and show you how the Federal Bureau of Investigation has used criminal prosecution as a means to attack and undermine racial justice advocacy. But some of the other things that they've done has to do with influencing public opinion through placing materials in newspapers that were friendly to the Bureau and the Bureau's efforts. And this would include information as well as disinformation. Also, the Bureau has always maintained an active public relations arm, and they have continued to promote the FBI as a heroic organization in the media. I think today there are 3 different television programs that focus on the heroics of the FBI. And historically, certainly people in my generation know that this was a part of the public entertainment in the United States to elevate the status of the FBI. In addition, they're involved in extensive surveillance and collecting information on people who are suspected government critics, as I mentioned before about about Reverend Williams. And they've also engaged in directing paid informants to infiltrate racial justice organizations, to foment dissension within these organizations or among the organizations. And this dissension has led to violence and lethal violence in a number of cases. That's sort of like is a range of things that have been done, but I want to talk more about criminal prosecution as a method of disruption. Now, I mentioned earlier multiple eyewitness misidentification. Obviously, there's a tremendous amount of literature that comes from psychology focused on the different types of evidence and the role that they play in wrongful conviction. Most people know that eyewitness misidentification is the single largest contributor to wrongful conviction. And I'm going to talk today about a particular type of eyewitness misidentification, which I refer to as a multiple eyewitness misidentification, where the prosecution will present multiple witnesses who will provide incriminating evidence for the prosecution, and we'll look at how is it that they are able to get these multiple witnesses, multiple eyewitnesses. Obviously, if there's one eyewitness that informs the state's case, a juror might be somewhat skeptical of the case. But if the prosecution can present two eyewitnesses, or three, or four or five, makes the case very strong and very compelling. And it begs the question, well, how is it that they get 2, 3, 4, 5 eyewitnesses if in fact the person's innocent? And hopefully, as I get through this, that'll become clearer. So in this table, I have a few cases of well-known illustrative multiple eyewitness misidentification wrongful convictions. These particular cases I'm talking about now did not involve the FBI, but I want to present them to illustrate some of the points, and in a moment we'll look at the FBI cases. First one I have here is Fernando Bermudez. And Fernando Bermudez was convicted in 1992 here in New York, in Manhattan, and he remained in prison until 2009 when he was exonerated and released. Bermudez was charged with a murder. He was charged with the murder of a young Black man outside of a nightclub in Lower Manhattan. And the state presented 5 eyewitnesses who testified that Bermudez was the one who shot Raymond Blunt with a handgun. So how did they get these 5 people to give this testimony? Well, they began with an incentivized witness. What does that mean? There was a witness for the prosecution who was receiving some additional benefit for his or her testimony. So this case involved a young man who was only 16 years old, who was in the nightclub that night. His name was Efren Lopez. And Efren Lopez was assaulted by Raymond Blunt inside the nightclub. And then outside of the nightclub, when everybody left the nightclub, Raymond Blunt was shot. And the police believed that Efren Lopez told someone, Blunt is a man that attacked me, and that someone shot and killed the victim, Raymond Blunt. But what was not exposed initially at trial was that Efren was incentivized in this way. The police told him that they were going to charge him as accessory to murder if he didn't cooperate. So with that, he obviously had a tremendous incentive to give the police evidence that they could use. He identified Bermudez from a headshot photo. And then after he identified Bermudez from the headshot photo, the police investigators sequestered 4 other witnesses together in a group and had them deliberate and let them know that Fernando Bermudez's photo had already been identified by Mr. Lopez. And those 4 people basically, they conferred for a period of time, and they agreed, yes, it was Mr. Bermudez. And that's how they got the 5 witnesses to testify against Bermudez at trial. Bermudez was exonerated, and he won a substantial civil award. I think he got like $5 million, a little short of $5 million for his period of wrongful incarceration. So that's one case with the multiple eyewitnesses. Let me talk about another one. Thomas Hainsworth. This was a prosecution from Richmond, Virginia, in the mid-1980s. This was a cross-racial stranger rape situation where 5 white women were raped or were subject to an attempted rape in one particular area of Richmond, Virginia. And Hainsworth became a suspect. He was identified by one of the rape victims, and then he was subsequently identified by 4 other rape victims, because it was a series of rapes that were being investigated at that time. There are a lot of difficulties with investigating stranger rape, and particularly cross-racial stranger rapes because of the cross-racial challenge in identification. I imagine most people are familiar with that. And actually, Dr. Pearl mentioned my book on wrongful conviction and sexual assault. It focuses on this problem with stranger rape and how and why cross-racial stranger rapes are dramatically overrepresented among the wrongful convictions in the United States. But what happened in this case was that after the original victim misidentified Hainsworth, that knowledge was maintained by the police investigators who subsequently approached other of the victims, and they lined up and all identified Hainsworth. Another complicating thing in this case, which I should acknowledge and mention, is that Hainsworth actually was rather similar in appearance to the man who actually was the rapist. So that contributed as well. But this is the type of thing that people need to know if they're confronted with a set of case facts where you have these multiple eyewitness misidentifications. So I want to mention the Kurt Bloodsworth case, and then I'm not going to mention the other two I have listed here. But Kurt Bloodsworth was another defendant who was charged with rape and murder. This was actually a capital prosecution out of the state of Maryland. In 1985, it was a child victim who was abducted, raped, and murdered, and her body was found in a wooded area. And the prosecution was able to present 5 so-called eyewitnesses to identify Kurt Bloodsworth as the man who abducted and assaulted this child. This was not a cross-racial case. Kurt Bloodsworth was a white defendant, and the victim was a young white child, a 9-year-old child. It was a stranger rape case, however. But one of the key features in this case that facilitated the multiple eyewitness misidentification was the use of a composite sketch. The child was last seen by 2 other children in a park area. And the other 2 children, one was a 10-year-old, the other was a 6-year-old. So the law enforcement investigation focused on those 2 potential witnesses, those 2 young children. And forensic artists worked with those 2 children to create a composite sketch based upon their memory of the man they saw with the child victim. And at trial, those 2 children became 2 of the witnesses against Kurt Bloodsworth. So where did the 3rd witness come from? After they had a composite sketch, again, it's generated by 10-year-old and 6-year-old boys. They had a composite sketch, they put it in the newspaper to see if anybody could identify someone that looked like this. Somebody came forward and said, that sketch looks like Kurt Bloodsworth. So the police brought Kurt Bloodsworth in for questioning. Reportedly, he had some problems with his alibi for the time associated with the crime. And he also made remarks during the initial interviews that the police interpreted to be incriminating. And with that, Bloodsworth was arrested and charged. When he was arrested, they put his actual photo in the newspaper. And when his photo came out in the newspaper, 2 other people came forward and said, aha, that is the man I saw with the child that day. Or that is the man I saw near the scene of the crime on that day. And that's how they got 5 so-called eyewitnesses to appear in court and testify. Okay, so I'm gonna move on. I won't have much time if we talk about these other cases, but this phenomenon of multiple eyewitness misidentification is actually rather common. This slide I'm actually going to skip. This is just like a brief review of some of the empirical lab research on co-witness contamination, how multiple witnesses, if they confer, they can influence each other's memory, and also the degree of confidence people have in their identifications. This slide sort of goes to the heart of my presentation, and here I present actual cases of wrongful conviction that were facilitated by the FBI. As you'll see in the two bolded cases, Geronimo Pratt and Aziz and Islam, these both involve multiple eyewitness misidentification. I'm gonna go into them in a few minutes, but I want to talk briefly about Martin Sastry and Deruba Benwada prior to those two. Martin Sastry was convicted of narcotics, a narcotics transaction in 1968. I'll tell you why I hesitated before I said narcotics transition. Martin Sastry was actually was arrested and charged with riot, arson, assault, and narcotics distribution. Those were the charges against them. This emerged right after the urban uprising in Buffalo, New York in 1967. And Martin Sastry owned a radical bookstore, and the local authorities thought he was in some way responsible for the urban rebellion that occurred that summer, despite the fact that in the summer of 1967, there were urban rebellions in like 20 different cities across the United States. But they decided that they were going to prosecute Sastry. And this is how they conducted the prosecution of Sastry. There was another Black man by the name of Arto Williams, who was in jail in Buffalo. And Arto Williams was a low-level criminal and a drug addict. They approached Arto Williams. Maybe they approached others as well. We don't know, but we know they approached Arto Williams, and they made an agreement with Arto Williams that they would release him from jail if he would cooperate with them in the prosecution of Martin Sastry. And they gave Arto Williams some marked bills and told him to take the marked bills and leave the money with Martin Sastry. Later that night, local police, along with FBI agents, went to Martin Sastry's store, arrested him, confiscated the marked bills, and Arto Williams testified at Sastry's trial that he purchased narcotics from Sastry with the marked bills. And that was the evidence that they had to convict Martin Sastry. Martin Sastry had earlier been in prison on a narcotics charge. And when he was in prison, he was an extremely effective jailhouse lawyer. And he actually challenged the New York State correction system. He sued the New York State's correction system in federal court, which was unprecedented at the time. And in that way, he established certain prisoner rights for those who were incarcerated. So this was an additional reason why they targeted and went after Sastry. He remained in prison until 1976. He was never formally exonerated, but he was released on clemency by New York Governor Hugh Carey in 1976. Deruba Benwada was a member of the New York City Black Panther Party. And in 1971, he was charged with attempted murder of two uniformed police officers who were guarding the home of a New York judge. I wish I had more time to go into the details because so much of the important points are in the details. But essentially, the case against Deruba that the District Attorney of New York presented relied on the testimony of a witness, a woman by the name of Pauline Joseph. And she testified at Deruba's trial that she was with Deruba prior to the shooting of the police officers, as well as she saw him right after he fired the rifle at them. And as she said, the rifle was still warm when she saw him after the fact. And essentially, it was her testimony that led to Deruba's conviction. There were some other disputes about some of the ballistics, but it's not that relevant to what we're looking at. But what is very relevant is that Deruba was convicted in 1973. 2 years later, in 1975, he filed a civil suit against the FBI and against the NYPD. And he alleged that his prosecution was part of the COINTELPRO campaign or initiative against the Black Panther Party and other racial justice advocates. And as a result of the civil suit and the documents that were made available to his attorney through discovery, they were able to, how should I say, they were able to explicitly show that Dhoruba was mentioned in internal FBI documents that he was someone that they needed to go after to neutralize, which was the term Hoover used for him to be neutralized. They also found in the discovery that there had been aspects of Pauline Joseph's testimony that were actually exculpatory, that actually indicated Dhoruba had not been the person that shot at the officers, but that she had changed her testimony during the times that they interviewed her. So it would correlate with what the prosecutor and the FBI wanted. And with those findings, Dhoruba was his conviction was reversed. He was eventually released, and he won a $4 million settlement from the FBI, as well as a $4.75 million settlement from the state of New York. So that was Dhoruba and how he was a racial justice advocate, and how his conviction was arranged by the FBI. Interestingly, I'm going to talk about Elmer Geronimo Pratt now, and actually the attorney that represented Dhoruba also later represented Elmer Geronimo Pratt. Pratt's case is real complex, and I'm looking at my time, but I want to try to get in as much as I can about it. In this photo, you see Elmer Geronimo Pratt, and you see his defense attorney, Johnny Cochran. Johnny Cochran is pretty well known at this point. He was not a national figure in 1972 when he originally represented Dhoruba. I want to read a brief quote from Cochran, where he talked about his representation of Pratt. And hope I brought my correct document here. Let's see. Okay, this is what Cochran said regarding Pratt's first trial, because Pratt was convicted at his first trial. Johnny Cochran said, "It taught me and a lot of other lawyers never to accept the official version of an event, never accept a lab report, a forensic finding, never take a so-called expert testimony at face value. It taught me to check everything and then check it again. As a result, I see things I never saw before, and I ask questions I never asked before." Obviously, Geronimo Pratt was devastated when he was convicted of murder, and I'm going to talk about the murder in a minute. But Johnny Cochran was also disappointed. It's probably an understatement. He was also devastated. At the time when Elmer Pratt recruited Johnny Cochran to represent him, Johnny Cochran had defended 10 different defendants in murder cases, and they had all been acquitted. So he was rather confident he was going to acquit Elmer Pratt, and he believed in Elmer Pratt's innocence, and he was obviously devastated. So let's see if we can look at what happened in the case, and also the multiple eyewitness misidentification element. So this is a timeline I tried to put together that hopefully help me share this information with you. Let's see here. The crime occurred on December 18th, 1968, and it was known in the press in California as the Santa Monica tennis court murder. And two people, a couple actually, Kenneth Olson and his wife, I believe her name was Carolyn, were playing tennis. Sorry about that. We're playing tennis, and in the evening they were under lights on a lighted tennis court, and they were approached by two black males, and who were armed, and these men robbed them, and then shot at both of them. And tragically, Carolyn Olson did not survive. She died 11 days after that. But her husband, Kenneth, did survive. And so he became one of the eyewitnesses. And there was a report from a store owner that she had seen these two men in the store shortly before the assaults occurred. And her name was Barbara Reed, I believe. And so Barbara Reed and Kenneth Olson were two potential eyewitnesses. They gave descriptions of the black male assailants. And I'm not going to go to all the details of the descriptions, but I think many of you are aware of the fact that there were some immediate challenges that were presented by these facts of the case. So number one, there were cross-racial identifications, and cross-racial identifications have a decreased level of reliability compared to within-race identifications. Obviously, it was a high-stress situation, especially for Kenneth Olson, and also was when weapons are used in an offense, it makes it more difficult for witnesses to give accurate descriptions of or make accurate identifications. Seeing now, I'm going to have to go through this much quicker. So Olson and Barbara Reed worked with the Santa Monica authorities, going over photographs and mugshots, trying to identify the assailants. And this went on for almost 2 years, and it looked like the case was going to go cold. But then something else emerged. Julius Butler, who was a former Black Panther Party member, he stated that Elmer Geronimo Pratt confessed to him that he actually committed the Santa Monica tennis court murder along with an accomplice. So at that point, the LA District Attorney's Office took over the investigation from the Santa Monica authorities. And they had Kenneth Olson and Barbara Reed in to do photo identifications. And as you can imagine, they both identified Geronimo Pratt as one of the assailants. And with that evidence, they proceeded to indict Geronimo Pratt. And then 2 years later, they went to trial. So they go to trial, and Johnny Cochran is startled as the trial begins and continues at the competence of the district attorneys who were prosecuting the case. They're great. They're perfect. Cochran says that every time he planned to advance a legal strategy, a legal argument on behalf of Pratt, that the DA sort of, it was almost as though they anticipated it, and they had an answer or a challenge to everything he wanted to present. And I should say, Cochran used to work for the Los Angeles District Attorney, so he knew many of these attorneys, and he's surprised at how effective they're being in this case against him. He called an expert in eyewitness identification, a Dr. Buckout, who actually was a really pioneer in this area, and he did testify on a lot of these cases back in the 70s and so forth and so on. But Pratt was convicted at trial, despite Cochran's efforts and the efforts of the maybe I should say the efforts, but despite the testimony of the expert. 2 days after the conviction, Cochran receives a phone call from a public defender in Santa Monica by the name of Lawrence Revitz. And Revitz says that there was a major irregularity in their trial because Kenneth Olson previously identified a different man as the assailant upon him and his wife. And Revitz knows this because Revitz represented that other man, his name was Perkins, at the live lineup, during the live lineup. So this meant that Olson had perjured himself during his trial testimony against Pratt. Cochran filed for an appeal with the original trial judge. She did not accept it, and Pratt's conviction remained. So for the second time, I'm going to have to speed forward. But Pratt remains in prison up until 1997. So from 1972 until 1997, he remains in prison. He files multiple, he through his attorneys files multiple appeals trying to challenge his sentence. And he finally prevails in 1997 and is released and received a multi-million-dollar settlement from the FBI and the LA district attorney. Now, you might wonder, why did the FBI have to pay? So let me point these things out. What they found was that at the time of this murder occurred, Geronimo Pratt was actually not in Los Angeles. He was not in Southern California. He was in Northern California, in Oakland, at a Black Panther Party meeting, series of meetings over a 5-day period. The FBI knew he was in Oakland because they had surveillance and wiretaps on the Black Panther Party meeting up in Oakland. So they knew he was innocent all this time. In addition, Julius Butler, the former Black Panther member who said that Pratt confessed to the crime and testified at Pratt's trial, he was also an FBI informant. He was on the FBI payroll while he was a member of the Black Panther Party. So this whole concoction about Pratt committing the crime was all a fabrication by the FBI that the Los Angeles district attorney went along with because they were trying to get rid of Pratt. And unfortunately, I'm not going to have the time to tell you about Pratt's special skills as a racial justice advocate, which I believe contributed to their targeting of him. But I do want to mention this particular point. The Los Angeles district attorney and the FBI, when they first took control of the investigation away from the Santa Monica authorities, they went out and apprehended a young man named Tyrone Hutchinson. He was only like 22, 21 years old. He was a low-level member of the Black Panther Party. And they charged him, they told him they were going to charge him with committing this crime with Pratt. And they told him if he cooperated, they would go easy on him. However, he told them, he says, no, I'm not cooperating with you all because I didn't commit the crime. Geronimo Pratt didn't commit the crime either. I know who did commit the crime. The crime was committed by Herbert Swilley and Larry Hatter, who were two heroin addicts from South Central Los Angeles. And Hutchinson said, I know that they committed the crime because they admitted the crime to me. And when they admitted to me, there were two other people present who also know about it. So I'm not going to cooperate with you. So therefore, they could not bring Hutchinson into their scheme to prosecute against Pratt. But they were aware of it. And they neglected to contact these other two men that Hutchinson mentioned, who also knew that these murders were committed by Swilley and Hatter, the two people I just mentioned. During the period when Pratt was seeking, following his multiple appeals, his defense team was joined by, as I mentioned, Robert Bloom, who was attorney for DeRoba, and also was joined by Jim McCloskey. I hope some of you know who Jim McCloskey is. He's the director of Centurion Ministries out of New Jersey. And he actually runs the original Innocence Project that was up and operating before Sheck and Newfield started the Innocence Project. But he joined the Pratt team, and he did extensive investigations all around the country and found all of these people and showed that this was all exculpatory evidence that was not shared for the sake of was not shared with Pratt's defense. It was also determined that the FBI and that the FBI had a plant in among Cochran's defense staff. It was either in Cochran's defense staff or Cochran had a co-counsel named Culpepper that the FBI had contacted someone like the junior attorneys or a office manager or something, and that's how they knew the defense strategy that Cochran was going to pursue, and they were able to always anticipate it and undermine it. And so these were a variety of different findings that were made eventually in a federal court hearing that led to the reversal of Pratt's conviction. And I don't have much time left. I'm going to take 2 or 3 minutes to talk about the exoneration of Muhammad Aziz and Khalil Islam. These were 2 men who were convicted of the murder of Malcolm X here in Manhattan in 1965. Actually, they were exonerated in 2021. And when I learned about their exoneration, that really led me, or essentially led me to begin looking at this stuff more closely, because I was interested in multiple eyewitness misidentification, and I had mentioned it in some of my earlier publications. But one of the remarkable things about the wrongful conviction of Aziz and Islam was that not only that they were misidentified, but they were not even at the scene of the crime. They were not at the Audubon Ballroom when Malcolm X was killed. But the Manhattan District Attorney was able to still indict and convict them. The indictment actually occurred only 17 days after Malcolm X was killed. That's pretty remarkable in and of itself, that they indict somebody for a major murder after doing only 17 days investigation. But I wish I could tell you the whole story, but I'm gonna tell you the short story. The short story is, how was it that they got these multiple people to say that Aziz and Islam committed the murder? Because the Nation of Islam and Malcolm X's new organization, the Organization for African American Unity, were both infiltrated by FBI informants. And these FBI informants came forward during the investigation, and they geared the investigation toward Aziz and Islam and away from the men who actually assaulted and killed Malcolm X. And in that way, they protected those people who actually killed Malcolm X. And I want to say, because obviously I'm summarizing a lot of material here, I just want to be clear about this. There were 3 men convicted of killing Malcolm X. One of whom actually was involved in killing Malcolm X, but the other 2 were not. And there were at least 2 or 3 other men who we know now post-conviction were involved in the actual gunfire that resulted in the death of Malcolm X. So I don't have much time left. I'm hoping I have a few comments or questions, and I want to thank everybody for paying attention, and hopefully what I delivered was clear.
Yes, thank you so much, Dr. Johnson, for going over some of this this historical lens here. I know that you have a lot more, a well of information that you could share with us. Like you said, you want to open it for questions, and we appreciate that. If you have any questions for Dr. Johnson, you can feel free to enter more in the Q&A box whenever you have questions. In the meantime, the survey for those that are pursuing APA continuing education credits is now available in the chat box. You can click that link and go ahead and fill that out or bookmark it otherwise right now. Somebody did comment about the Aziz and Islam situation that you mentioned, that they believe there's a documentary on Netflix right now that discusses their exoneration. Indeed. Somebody asked more broadly, is there an opportunity to hear more detailed information about these cases, your presentation? Basically, where can they get more about these particular examples?
Well, I'm working on a couple of manuscripts right now. A lot of what I said first, everything I've said is from publicly sourced material. There aren't many confidential documents I have. And particularly the Aziz in Islam exoneration, the Ruba bin Wadi exoneration, and I'm trying to think what the other one I mentioned, but they're all on the National Registry of Exonerations. So if you go to the National Registry, they report this, including the involvement of the FBI.
Wonderful. Thank you for that. There have been, known struggles and complications for people that have been exonerated in terms of outcomes of their civil suits. And I was wondering if you had any information on the civil suit outcomes, if there have been any for racial justice advocates that have later been exonerated.
That's not something that I've really looked at. I know that many people have won these civil awards. Some have fared not as well as others. Um, Daruba Benwada is still alive and somewhat active, actually quite active. Um, Muhammad Aziz, I think he's in his early 80s, and he, just a couple of years ago received his award. Gratefully, um, with Aziz, Aziz's wife and family, they knew he was innocent because they were with him on that day, and they actually testified as alibi witnesses for him. So even though the ordeal has been horrible, I mean, to say the least, his family always knew that he was innocent, and obviously they're grateful that it's been acknowledged, and he's been, I would say, partially compensated for what he lost. But I don't know a lot about that. It's almost like a different specialty in wrongful conviction, like how people adjust after the fact. And I'm still working on, what can we learn to try to prevent these people from getting convicted.
In the first place. Yes, certainly. Somebody asked whatever happened to the mole in Johnny Cochran's office.
It was never identified who it was.
Never identified.
Let me explain that, because if in fact the FBI facilitator listed a mole, they won't divulge that person's name. Then the courts won't force them to divulge that person's name. And there's a doctrine, I can't think of it right now, but where they have the discretion to protect sources and so forth and so on. So that person was never identified, or certainly wasn't publicly identified.
Somebody asked if the FBI has ever publicly apologized for any of these actions, and then somebody asked, do you see a path for holding the FBI and the legal system accountable for these kinds of incidences moving forward?
I don't know of any FBI apologies. Typically, what is in the script is that they are making financial settlements, and these settlements should not be interpreted to mean that they were necessarily guilty, which is common in civil proceedings. So I don't think there have been any apologies, but I can't say definitely.
Have you seen any particular commonalities among the particular racial justice advocates that seem to be increased target of prosecution relative to other racial justice?
Well, certainly, the more effective the racial justice advocates are, the more likely they are to come under the radar, to be surveilled, and for there to be efforts to disrupt them. The efforts to disrupt them are different. What I didn't mention Martin Luther King in 1963. The FBI prepared a confidential memo on Dr. King, where they described him as an unprincipled and opportunistic individual. That's a direct quote. And they said that he was a danger because he was trying to build a Negro labor alliance, a Negro labor coalition, and that was going to be a step toward communism. And I'm not exaggerating, and this sounds kind of funny now, but this was the language in this document. And I actually have the document. I have a copy of it because it became public record. But this was an example of how they would, of the attack on Dr. King. There were other aspects to the attack on Dr. King as well. It's pretty widely known now that Dr. King had some extramarital affairs, and they tried to use that to bribe him. And they also tried to use that to discredit him to other civil rights leaders and so forth and so on. So I'm trying to remember what else. I mean, people know that Fred Hampton, the Black Panther leader, the young Black Panther leader from Chicago, that he was murdered by the Chicago police, and that was done in concert with the FBI handler who had infiltrated the Black Panthers in Chicago. So it appears as though that people who they consider to be threatening we're more likely to become targets. That's sort of the simple answer.
And a couple of people have asked as we reach the top of the hour here, are there any relatively recent cases that you know of where there's currently ongoing looking at whether it's the prosecution or actually conviction of racial justice advocates?
Yeah, let me say, I can't point to a case right now, but let me say this. What happened was after the Senate Select Committee report that came out in 1976 on the abuse of intelligence services in the United States, the FBI was directed to no longer conduct investigations against people unless there was some, not presumption, there was some evidence that their criminality was involved. And they FBI operated under that guideline up until 2008, when Michael Mukasey was the Attorney General during the George W. Bush administration. And he rewrote these guidelines, and he articulated this approach where he said that um, investigations cannot be conducted unless there is I think the legal term, predicate of criminality. But it's the FBI is authorized to conduct assessments, which is a semantic difference. They can conduct assessments even if there aren't a predicate for criminality. And under that rubric, they were able to broaden and renew their investigation. A lot of that was focused on people that were thought to be, Islamic and Arabic groups that were thought to have some kind of connection with the Al-Qaeda and the whole, the post 9/11 world and so forth and so on. And then also the FBI invented this new classification called Black radical extremism, or something, Black identity extremists. So they went around, there's certain groups they said were Black identity extremists, and then they used that as a justification to investigate them, but call it an assessment rather than an investigation. And there's some cases that fall under that rubric, and actually the article by Meehan that I just mentioned briefly earlier in my talk, she goes into that in greater detail. And I haven't digested it adequately to talk about it right now.
Certainly. Well, Dr. Johnson, thank you so much for the analysis and voice that you have given for wrongful convictions of racial justice advocates, and for sharing all of this information today with us in the Law and Mental Health series. People commenting good presence as always. Thank you. Somebody discussing the fascinating in the context of the potential to misuse new technology like deepfakes in these situations as things emerge. So yes, thank you so much for sharing all of this with us today, and it is much appreciated, and good to see you, of course. Yes.
Okay, thank you so much. I appreciate being here.
Yeah. And that wraps up this week's Law and Mental Health series. Next week, we have Dr. Evan August and Dr. Mark Bolden, who will be discussing historical and ethical views of forensic psychology through the lens of Black psychology. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.